The U.S. Appeals Court has ruled New Jersey's ban on assault rifles is unconstitutional.
From the Supreme Court, the justices announcing they will consider striking down bans on assault weapons like the one in Connecticut.
President of the Connecticut Citizens Defense League, these laws ultimately violate constitutional rights.
The Appeals Court has ruled that a state's assault weapons ban violated the U.S. Constitution's Second Amendment.
What if a single legal decision instantly transformed millions of everyday citizens from potential felons back into law-abiding gun owners overnight? For years, gun owners across the country have watched a massive legal tug-of-war play out in the federal courts. Many have been left to wonder if their constitutional rights would survive the decade. But a massive, unexpected shift just occurred in the federal judiciary, and it is sending shockwaves through state capitals from coast to coast. A prominent federal appeals court has just issued a monumental ruling completely dismantling strict state-level firearm bans and labeling them fundamentally unconstitutional. This isn't just a minor victory or a temporary pause. It is a systematic legal wrecking ball that targets the very foundation of modern civilian disarmament efforts. The decision has immediately reignited a fierce national debate and set the stage for a dramatic showdown at the highest level of American law. To understand how we arrived at this explosive turning point, we have to look closely at a critical legal battle out of the Mid-Atlantic region, the high-profile case known as Cheeseman versus Platkin. For months, legal observers assumed this specific challenge against strict state regulations would be quietly put on ice. The general expectation was that the appellate judges would sit on their hands waiting for the United States Supreme Court to hand down guidance in a separate, heavily watched case out of Illinois. That case involves Viramontes versus Cook County, but the appellate bench threw a massive curveball. Instead of waiting, the judges abruptly demanded expedited supplemental briefing from both sides. This unusually rapid timeline strongly signaled to seasoned court watchers that the bench was locked, loaded, and eager to drop a major opinion. When the final ruling was unsealed, it was far more sweeping than almost anyone anticipated. The court didn't just trim the edges of the state's restrictive firearm policies. It took a scalpel to the entire regulatory framework. The core of this intense legal fight centers on two of the most controversial pieces of firearm legislation in modern American history. The first is an outright ban on a broad category of semi-automatic firearms, often labeled by politicians as assault weapons. The second is a strict cap on magazine capacities, which limited residence to a maximum of 10 rounds. At the initial district court level, the presiding judge issued a somewhat split, compromising decision. That lower court ruled that specifically banning the iconic Colt AR-15 rifle crossed a constitutional line, but it simultaneously upheld the state's strict 10-round magazine limit. Unhappy with this half measure, the appellate court stepped in to review the case, and their final order fundamentally altered the playing field. The higher court affirmed that banning the Colt AR-15 was indeed unconstitutional, but then they went several massive steps further. They modified the order to declare that the ban was unconstitutional as applied to the entire class of semi-automatic rifles. Then, turning their attention to the magazine restrictions, the appellate judges completely reversed the lower court's finding. They declared that capacity limits also flagrantly violate the Second Amendment. But how did the court justify such a radical departure from the prevailing legislative trends? The answer lies in a strict, unyielding application of the supreme legal standard established by the High Court a few years ago, the landmark Bruen framework. Under this modern legal test, gun control laws can no longer be justified by balancing public safety statistics or legislative intent. Instead, courts must follow a strict two-step formula. First, they must ask a simple text-based question. Does the plain text of the Second Amendment cover the citizen's conduct? If the answer is yes, the law is presumptively unconstitutional. The burden then shifts entirely to the government to prove a second, much harder point. They must show that the modern restriction aligns seamlessly with the historical tradition of firearm regulation in the United States. This historical inquiry immediately triggers a fascinating, high-stakes debate over which specific era of American history actually matters when interpreting the Constitution. During the appellate proceedings, the state's legal teams attempted a creative historical defense. They pointed to a flurry of restrictive state and local laws passed during the mid to late 19th century. They argued that these older statutes proved a long-standing American tradition of regulating dangerous weapons. However, the appellate court flatly rejected this timeline. The judges noted an irreconcilable conflict between the broad freedoms enjoyed during the founding era of the late 1700s and the increasingly restrictive local laws passed a century later. The court ruled unequivocally that judges must anchor their understanding in the founding era, specifically around 1791, when the Bill of Rights was officially ratified. The reasoning is clear and fixed. The true meaning of a constitutional amendment is locked into place by the public understanding of the generations who actually voted to adopt it. Post-enactment history from the late 1800s cannot be used to distort or overwrite that original intent. That means the state's historical arguments were dead on arrival. With the historical timeline firmly locked into the late 18th century, the appellate court turned its focus to a critical judicial tool known as the common use test. For years, anti-gun advocates and sympathetic judges have attempted to muddy the waters, arguing over what it actually means for a firearm to be in common use. The appellate court's opinion cut straight through the noise with refreshing clarity. The court established that in common use simply means a firearm or component is widely possessed by millions of citizens for entirely lawful purposes today.
A military-grade weapon on the streets of Chicago is simply unacceptable.
Allow people to have weapons to defend themselves. They don't need a weapon that can fire that many bullets in a single second.
The only category of firearms that were banned were those that were clearly dangerous.
There have been more and more shootings. It is getting worse and worse. Mass shootings have occurred in the workplace, on college campuses.
Crucially, the judges clarified that while personal self-defense is the central pillar of the right to bear arms, it is far from the only lawful purpose that counts. If a weapon is widely used for recreational target shooting, competitive sports, or hunting, it automatically falls under the robust protective umbrella of the Second Amendment. This definition directly triggers an important legal concept: the historical tradition of banning weapons that are deemed both dangerous and unusual. For years, states have tried to argue that modern semi-automatic rifles are uniquely lethal, making them dangerous and unusual enough to warrant a total prohibition. However, the appellate court pointed out an obvious logical contradiction in that argument. Under American jurisprudence, the terms in common use and dangerous and unusual are completely mutually exclusive. If a specific type of firearm is owned by millions of peaceful citizens, it cannot, by definition, be considered unusual. The court highlighted official data showing that there are currently an estimated 24 million AR-15 style rifles in active circulation across the United States. That staggering figure is surpassed only by the total number of registered handgun owners nationwide. Because these rifles are overwhelmingly chosen by law-abiding society, they are undeniably in common use. That makes any attempt to classify them as dangerous and unusual intellectually dishonest. The state's defense team then attempted a highly emotional pivot. They argued that modern societal problems, specifically the horror of mass shootings, constituted an unprecedented emergency that required a more flexible, nuanced interpretation of history. They argued that because the Founding Fathers never had to contend with modern mass violence, modern legislatures must be given the leeway to adapt. Once again, the appellate court was entirely unpersuaded. The judges noted that the core societal concern, the tragic reality of individuals misusing weapons to harm or menace others, has persisted since the dawn of the Republic. The founders were well aware of violent crime and malicious actors. They easily could have adopted broad, sweeping weapon prohibitions to confront the problem in the 1790s. They explicitly chose not to. Therefore, the court ruled that an outright ban on an entire class of popular firearms is a blunt, historical anomaly that completely fails the Bruen standard. This holds true regardless of the well-intentioned motives of modern politicians. But what about the separate issue of ammunition containers? This is where the appellate court's ruling gets incredibly interesting. They took a definitive stance on a question that has divided lower courts for a decade. Do detachable magazines actually count as arms under the Second Amendment? Many restrictive states have successfully argued that a magazine is merely an unregulated accessory, a separate mechanical component that does not enjoy any constitutional protection on its own. By using this loophole, states claimed they could ban high-capacity magazines without ever having to justify the restriction historically. The appellate court completely shut down this legal maneuver, applying a dose of basic common sense. The judges noted that the Supreme Court has long defined arms broadly to include any instrument that a person takes into their hands to cast or strike at an adversary. Because a modern semi-automatic firearm requires a detachable magazine to function as intended, the magazine unquestionably facilitates the user's ability to defend themselves. Without the magazine, the rifle is rendered a useless piece of heavy plastic and steel. Therefore, magazines are fundamentally arms, and any law restricting them must face the exact same strict historical scrutiny as the firearms themselves. This led the court to confront what gun rights attorneys call the magic bullet theory. This is the highly criticized legal idea adopted by some jurisdictions suggesting that a magazine is perfectly protected by the Constitution while it holds 10 rounds. But the exact second and 11th bullet is inserted, it magically transforms into an unprotected, dangerous public hazard. The appellate court dismissed this notion entirely. They stated that absolutely nothing in the text of the Second Amendment suggests that a component's constitutional status fluctuates based on its numerical capacity. A magazine is an arm, whether it holds 5 rounds, 10 rounds, or 30 rounds, and because standard capacity magazines holding more than 10 rounds are numbering in the hundreds of millions across American households, they are undeniably in common use for lawful purposes. Consequently, the state's strict 10-round limit crumbled under judicial review. The immediate fallout from this massive legal defeat has thrown state officials into a state of absolute panic. Almost immediately after the ruling was handed down, legislative leaders began scrambling to draft emergency placeholder statutes. They were desperately searching for alternative legal language to restrict firearm sales before the market could adjust. The big question now is what happens next? Will local gun shops immediately begin stocking semi-automatic rifles and standard capacity magazines on their shelves? The reality is a bit more complicated as a massive legal chess match is about to unfold. The state will almost certainly file an emergency appeal, taking the case straight to the United States Supreme Court. Legal experts predict that the High Court will likely hold a quick conference on the matter and then temporarily place the case on ice. They would hold it in limbo until they issue a final, definitive ruling on the highly anticipated Viramontes case out of Cook County, Illinois. However, this temporary pause does not diminish the sheer historical weight of what just happened. Up until this point, if the Supreme Court wanted to strike down an assault weapon or magazine ban, they had very little support from the lower appellate courts. Every single federal circuit that had ruled on the issue in recent years had twisted itself into knots to uphold the restrictions. That unbroken wall of anti-gun judicial consensus has officially been shattered. With this new opinion, the Supreme Court now has a meticulously reasoned, rock-solid appellate framework to point to, completely validating the originalist interpretation of the Second Amendment. This caps off a remarkable 30-day stretch where gun rights advocates have secured unprecedented victories across the federal court system, fundamentally shifting the balance of legal power in America. That's it for today, folks. See you in the next video.